the excitement that was generated in 2011 about a potential upstream petroleum boom, an oil and gas boom, 4 years later hasn't really materialized because of legislative deadlock. Because the legislative future of upstream petroleum has been uncertain for so many years, exploration has simply not been happening. Foreign investors who expressed interest in 2011 and 2012 have simply not been able to proceed because the legislative framework is so uncertain. So there is some urgency to resolving this, at least to provide some kind of certainty to potential investors. The separation of upstream petroleum, which refers to the exploration and extraction of oil and gas, both offshore through seabed drilling and onshore through fracking of shale gas and extracting methane from coal. When we talk about upstream petroleum, we're really just talking about the exploration and extraction of the raw material. The upstream petroleum industry is governed from an empowerment perspective, by the Liquid Fuels Charter, which is very different from the Mining Charter. And of course, the Liquid Fuels Charter is monitored and administered by the Department of Energy, because it applies to downstream and midstream petroleum as well. And the Mining Charter is administered by the DMR. There are very different methodologies in the two charters and also different targets. So the Liquid Fuels Charter requires upstream petroleum companies to be 10% black owned, whereas of course, as you know, the Mining Charter requires companies to be 26% black owned. So the difference is really quite substantial in a practical sense. It's not simply a formal or theoretical distinction between the two departments. The separate regulation under one act has created this very awkward coexistence, a very uneasy coexistence that it is hoped could be resolved by separating out the petroleum chapters from the MPRDA into a new upstream petroleum bill or act. The stakes of this separation became considerably higher around about 2011, when the US Energy Information Agency released studies to the effect that South Africa has some of the largest reserves of shale gas in the world. According to their estimates, we would have 485 trillion cubic feet of recoverable shale gas in the Karoo Basin alone, which would put South Africa in 6th place in global shale gas reserves. These are very encouraging figures. There's also, of course, a lot of excitement about the potential of offshore petroleum, offshore oil drilling after the discovery of massive reserves of oil in neighboring Mozambique and a little bit further north in Tanzania. And South Africa, as a country that is a net petroleum importer, and of course with our tremendous energy constraints, has a lot of benefit to derive from tapping these reserves of onshore and offshore petroleum. There's a lot of value to be unlocked in the language used in the Oceans Pakisa project, initiated in 2014, which resulted in a series of workshops in 2015, where this question of separate regulation of oil and gas again was endorsed by industry and to some extent by the DMR within a certain period. One of the difficulties with that is that it's not clear who would control upstream petroleum if it is separated out. The comments by the Minister of Energy seem to suggest that the Department of Energy, as one would naturally expect, should exert control over upstream petroleum. But the Department of Mineral Resources doesn't seem to be on board with that proposition. They have been proceeding on the basis that upstream petroleum will be regulated by a regional office of the DMR. And it is likely that in the next few months, while the MPRDA amendment bill is being reconsidered by Parliament, that this will be one of the critical issues that might play out perhaps behind the scenes or perhaps publicly, is almost a potential turf war between the Department of Energy and the Department of Mineral Resources for control of a potentially very lucrative sector.